I'm Katherine Simpson and I'm a partner in the residential property team at Edwin Co. I'm going to talk about a very common scenario faced by many leaseholders who typically own a lease of a flat and a share in the company that owns the freehold interest in their building. Most of us are familiar with the sales path of those agents' particulars, boasting a wealth of period features, a bright and airy aspect, well-appointed accommodation. The list goes on, all pretty meaningless, but well-meant and entirely harmless. But what about the lure of share of freehold in the case of a leasehold flat? All fine if the lease was granted for 999 years when the freehold was acquired by the leaseholders, but nasty tax consequences can lurk if a different scenario presents itself. Many conveyancers acting for buyers overlook the need to investigate the position where the lease has not yet been extended, as it should have been when the freehold was acquired. Some crucial questions fall to be answered in these circumstances. It is not the case that just because you will be acquiring a share in the freehold, you and your fellow leaseholders can simply grant yourselves new leases at any time without any adverse tax consequences. You won't be paying anything as you already own the freehold. Depending on how the freehold interest is owned, there may be tax liabilities, both in terms of stamp duty land tax, SDLT, and capital gains. So that's capital gains tax, CGT for individuals, and for companies, a corporation tax liability. So let's take the typical scenario of a group of leaseholders who get together to acquire the freehold interest in their building from their landlord, whether by agreement or by exercising a statutory right. Most likely, they will set up a company to acquire and hold the freehold, with each of them having a share and so a voting right in the company. Where companies are set up with the specific purpose of acquiring and managing a building, the company's articles will usually stipulate that the shares can only be held by the flat owners, and that when someone sells their flat, they must also transfer their share. So together, the leaseholders share the ownership of the company's single asset, which is the building containing their flats. The key issue is how that asset is actually held by the company. Is it an asset of the company in the most transparent and absolute sense, or is it held by the company on trust for the leaseholders? If it is the former, a second SDLT event will arise on the grant of the new leases, whether they are granted immediately on the freehold acquisition or at a later date. The first SDLT event is, of course, the acquisition of the freehold itself. But how do you know if the freehold is held on trust? The most compelling factor is if the company has declared by deed that it holds the freehold on trust for the leaseholders and those to whom they sell their flats in the future. In the absence of an express declaration, a trust can quite often be implied or inferred. It's the same thing. The key question is whether it was the intention of the leaseholders when they acquired the freehold to hold it on trust for themselves. Quite possibly, especially if the leaseholders, as they most likely will, have differing tax circumstances. Also relevant is the fact that under a trust arrangement, in the absence of any agreement to the contrary, all decisions relating to the management of the building must be made by the leaseholders, rather than by the directors of the company. So, if there has been no express declaration, a trust might be said to be inferred by the fact that the leaseholders make all management decisions together. A trust might also be inferred if the freehold company is not collecting any ground rent from the leaseholders. A trust will easily be implied if the company accounts do not show the building as an asset of the company. Under a trust, the freehold is an asset owned by the leaseholders. These things are all key indicators of a trust. Unless a trust can be established, whether by inference or formal declaration, the freehold company might look for payment of a premium on the grant of the new lease. SDLT will be payable on that premium, which might be significant if the existing lease is getting short, typically less than 8 years left to run. A 3% SDLT surcharge might also apply if you own other residential property, whether in the UK or abroad, and the flat is not your main residence. Whilst a trust arrangement can nullify any SDLT liability for an individual leaseholder on the grant of the new leases, which would be for nil premium because of the trust arrangement, irrespective of when the leases are granted, the timing of such grant is critical in the context of any capital gains liability. It is imperative that the leases are granted immediately or as soon as possible after the acquisition of the freehold. I'm pausing slightly to look at the SDLT position where the leaseholder is a corporate entity as opposed to an individual. In those cases, SDLT will be payable on the premium as it will for an individual, but it will also be payable where no premium is paid, typically because a trust is inferred or otherwise formally declared. SDLT will be payable by a corporate leaseholder on the notional premium, which will be the market value of extending the lease. That liability can, however, be avoided by the corporate entity, in turn declaring that it holds leasehold interest on trust for an individual beneficiary. As far as the freehold company is concerned, the widely held view is that because the surrender and grant of the new lease is between the same parties, the freehold company will not be liable to SDLT on the surrender value of the existing lease. Tax specialists do, however, regard this as something of a grey area in the context of leaseholder-owned freehold companies, and so it's always worth seeking advice from an expert. So, back to the delay point. Where there is a delay in granting the new leases following the freehold acquisition, a capital gains liability may well arise for each leaseholder. The gain to each leaseholder on the grant of the 999-year lease arises on the related surrender of the existing lease. The gain is the difference in value between the lease being surrendered, the existing lease, which if the unexpired term is short, will have a rapidly dwindling value, and the new lease. The good thing is that no liability will arise for those leaseholders whose flat is elected as their principal private residence for CGT purposes. But for those who can't avail themselves of that relief, a CGT liability may well arise. The usual concession, known as a D39 concession, which applies to nullify a CGT liability in these circumstances, will not, however, apply where there has been a delay in granting the new lease following the freehold acquisition. If, however, a trust can be established, it is considered that the trust will absolve each leaseholder as beneficiary under the trust of any capital gains liability. So what about the freehold company? The grant of each lease functions as a partial disposal of the freehold, in respect of which a capital gain can arise unless the grant immediately follows the freehold acquisition, as not enough time will have passed to result in the accrual of any gain. The gain to the freehold company is the difference in price for the grant of the 999-year leases when the freehold was acquired and upon their actual grant. These issues present a cautionary tale for those buying a lease with a share of freehold. Where new leases haven't yet been granted, it is imperative that your conveyancer makes all appropriate inquiries to establish whether a trust exists and so whether a trust has been formally declared or whether it can otherwise be inferred, and so nullifying any CGT liability, and in many cases any SDLT liability. The severity of the CGT liability will depend on when the freehold was acquired. The longer ago, the greater the gain will be. Many of the flats will have changed hands over the years once the freehold was acquired, leaving the gains creeping up for the current leaseholders to bear, both as owners of the freehold company and as leaseholders. This is a clear and unequivocal message to seek specialist transactional advice if you are buying a new lease with a share of freehold. Here at Edwin Co, we specialise in these and all other landlord and tenant matters. If you have any questions or think you may be affected by these issues, please do contact me or a member of our team.